If you've moved to Puerto Rico and you're taking advantage of Act 22 benefits, you've endured hurricanes, earthquakes, blackouts, and now here comes the IRS. We'll break it down on this episode of Taking Shelter. I'm your host, Peter Paulson. I'm joined by my socially distanced colleague, Eli Knopf. Eli is the partner in charge of tax controversy at Frost Tax Law. He has extensive experience working with the IRS on tax controversy, and he is the incoming chair of the ABA's Subcommittee on Tax Collection. Welcome, Eli. Thanks for joining.
Thanks for having me.
Our topic today is the new IRS campaign that targets U.S. citizens who are enjoying the benefits of Act 22. If you want to catch up on what is Act 22 and its companion provision, Act 20, check out my other video on this channel. But essentially, Act 22 is an incentive in Puerto Rican tax law designed to attract investors to come to Puerto Rico by providing them with exemptions from tax for their investment income. And if you meet certain conditions, some or all of that income can be exempted from U.S. tax as well. And those conditions are the subject of this IRS campaign. In this episode, Eli and I are going to discuss the following questions. What is an IRS campaign in general? What is a specific Act 22 campaign? What happens next? How do you prepare? Is this the end of Act 22? And what about Act 20? So Eli, in a nutshell, what is an IRS campaign?
Well, thanks again, Peter, for having me. IRS campaigns are essentially areas of enforcement that the IRS determines where abuse is or may be ripe. And we've seen this many times before. For those of you who are familiar with the international tax compliance, the FBAR and FATCA campaigns, conservation easements, captive insurance, this is a similar type of campaign. They look to catch issues early and create a deterrent effect, essentially create an impact as early on as possible to really curb any possible abuse. Not to suggest that everyone using these acts is driving at some form of abuse, but they're looking to curb it where they believe it's ripe for abuse. Examinations can be very invasive and lengthy, and certainly something that people want to avoid.
Let's talk about what the IRS has said about this particular Act 22 campaign. They added a paragraph to their website on January 29th that is as follows. I'm going to read it here. This campaign addresses taxpayers who have claimed benefits through Puerto Rico Act 22, yada yada, without meeting the requirements of IRC Section 937, residence and source rules involving possessions. As a result, these individuals may be including income subject to U.S. tax on a filed U.S. income tax return or failing to file and report income subject to tax. So those are the kinds of abuses, I think, Eli, you talked about that they are tuned into here. And let me pause there. Some people might say, hey, I already have a contract with Puerto Rico that covers my tax situation. The Act 22 contract is not going to determine your U.S. tax outcome. If it did, the IRS would not be opening a campaign targeted at people who already have Act 22 contracts. So let me continue from the IRS site. This campaign will also address those individuals who have met the requirements of IRC Section 937 but may be erroneously reporting U.S. source income as Puerto Rican source income in order to avoid U.S. taxation. The objective of this campaign is to address noncompliance in this area through a variety of treatment streams, including examinations, outreach, and soft letters. So check it out, treatment streams. Eli, maybe they're just going to give everyone COVID vaccinations.
Wouldn't that be
Maybe.
nice?
That would be great. You can see from the emphasis I added, there are two focus issues, bona fide residence and source of income. Very old issues with some nuances with respect to the Puerto Rican situation. In the case of Act 22, the nuance has to do with a special rule that talks about gains that you bring to the island, gains that arise prior to the start of something called a possession holding period. Eli, what can an Act 22 holder expect to happen next?
The IRS approaches every campaign differently, and the way they ramp it up and the way they send out letters vary per campaign. However, analogizing it to cryptocurrency, in that campaign that is still ongoing, many of the Bitcoin enforcement has already gone out from that particular John Doe summons and the information the government received there. I'm sure there's more to come. However, with that particular campaign, the government sent out a few different letters, ranging from general education letters, very soft letters. Hi, you may have cryptocurrency, here's what you may need to consider. Something like that may be sent out in the Puerto Rico campaign. And it can range all the way to, we know you did something wrong, or we have knowledge that something is afoot and requires affirmative action to be taken. That knowledge that the government can now prove, sending a letter, educating a taxpayer, and it can be very helpful to the government from supporting either a civil penalty or potentially enforcing a criminal proceeding and using that as an exhibit in their criminal proceeding.
So Eli, the point is that there's a publication 570 that's out there that already is providing general information to the populace about the requirements under this Section 937. What you're saying is that the soft letters, because they're sent to individuals, create really a situation in which now you know and we know you know. Correct. As opposed to just having general information in the market.
As opposed to a taxpayer being able to say, I haven't read that particular publication or I haven't seen that guidance. Well, you have a letter in your mailbox that educated you. And that, for the most egregious cases, it would be supporting a criminal prosecution. For maybe somewhere in the middle of the road cases, it can support a penalty assertion for future years. And for less egregious cases, the letter, it really is just more of a wake-up call.
So if you get the wake-up call, if you get the letter, and you go back and you talk to someone and you decide that I have not treated my capital gains correctly, and you decide you want to amend the return, is this like an amnesty? Is it okay now you can amend your return because you got this letter and without penalties, or just how does that process work?
So that's a great question. So with all of these campaigns, really, the government has very limited resources. We all know that. They're not going to prosecute everyone. They're not going to audit everyone. But really, the primary goal over the years of working with deputy commissioners on various areas of tax, it's really behavior modification. That's the primary goal. So if there is a position that you've taken, you have a question about it, you're uncertain, I'd hire a professional to vet that position and ensure there's qualification for the benefits that are taken.
And that gets to the issue of preparation and how do you prepare. And I think this group should be fairly well prepared from a starter standpoint. You all live on the same island, and this is a big topic of conversation. I see your videos. A number of people put videos out. They talk about Act 20 and Act 22 to bring traffic to their channel. This could be the first IRS campaign that's effectively live streamed. So it's going to be interesting to see how this plays out. There is a lot of general information out there. There's publication 570. When you move to the island and you take up your bona fide residence, the IRS wants you to fill out Form 8898. It asks you about a page and a half of questions about your bona fide residence standpoint specific to you. Has about a half a page of questions about sourcing of income, including gains you might be bringing to the island. So there's I would really hope that not too many people are blindsided by this campaign. But what else might they want to do to get themselves in a position to best, in a sense, survive the campaign?
Again, a great question, and circling back around to your previous question, again, hiring a professional, vetting the position, and in the event an unsupported position was taken or an aggressive position was taken, you may want to consider coming into compliance with the IRS before they find you and avoid potential accuracy-related penalties on the civil side. And there are programs available outside the scope of this particular discussion that, hopefully we'll do something in the future on this, where there are actual areas of compliance. There's actual programs and procedures that have existed a long time in the Internal Revenue Manual, different practices where people who have taken aggressive positions with high dollars that are at significant risk and have exposure to come into compliance and potentially mitigate that criminal exposure by utilizing these already existing procedures. So if anyone has any questions about that, of course, we're glad to discuss them on an individual basis.
The interesting thing about this program is the IRS already has a lot of information on who's taking the benefits of Act 22, so it's not like the cryptocurrency blast, boil the ocean, and this is specific to 1,000, 2,000 people. Now let's talk about what impact an IRS campaign like this might have on the future of the tax benefits under Act 22 or the corresponding U.S. tax provisions. So Eli, let's say you're watching this video in the airport. You know where I'm going with this. You're watching this video in the airport in Miami. You just sold your house. You sold your car. You've rage quit your job. You told everybody on Facebook you're moving to, and now this campaign drops. What do you do?
Right. So again, that is a tough position to be in. However, I would take a step back. These are life-changing decisions. Certainly, we see this very frequently with people moving to no-tax states or low-tax states from high-tax states. And it happens often. People call us from the airport or the day before the flight, and there's a lot of positions and a lot of things and factors that they have not taken into consideration where they could have shored up their position a lot stronger and put themselves in a better spot should the IRS or a particular state taxing authority in that situation come at a later point in time to challenge them. So to answer your question, Peter, I think it's not necessarily don't board the flight, don't go. It's just do your proper homework, take the proper steps necessary to ensure that you put yourself in the best position to support the position you're going to be taking if the IRS comes in the future.
Yeah, and I'll kind of echo that and raise a couple other points. First of all, the IRS conducted a similar initiative. They weren't called campaigns back then, but they conducted a similar initiative in 2005 focused on the United States Virgin Islands, which had a similar incentive regime, a similar set of U.S. tax rules. And some of those controversies are still going on, believe it or not. But 15 years later, those provisions, both the incentives under USVI law and the application of the U.S. tax law, still exist. So I don't feel that there's much to react to immediately, but certainly a campaign and the information gained from a campaign can inform future tax policy. And that's another point, Eli. The IRS does not set tax policy. They enforce tax policy. And so if the law is to be changed, it's going to be changed by Congress. As I've said before, I don't believe this U.S. tax provision is a loophole because it applies to 3 million people, everybody who is resident in Puerto Rico. And if they change the law, they need to think about the consequences to all 3 million people. And if you look at the history here, that is very complicated. So for now, you need to be compliant with the law as it exists today. Final thoughts on preparation and Act 22?
So the IRS is essentially looking to curb abuse, right? And that's what these campaigns are driven at. That, education, and behavioral modification, correct? They're not there to set policy, they're there to enforce policy. However, what we've seen in other areas of enforcement and other campaigns is that there's a certain groundswell that comes with these campaigns and enforcement areas, particularly in international tax compliance, that perhaps maybe there'll be some lobbying efforts that come out of this enforcement to try to change things in the future. Look, the IRS doesn't need a campaign to examine a tax return, so taxpayers can be examined regardless of a campaign. And if you're concerned about your position, feel free to call us and we can discuss what we can do to help you out.
Yeah, so that last point about the IRS not needing to launch a campaign to examine tax returns, the final point is why wasn't Act 20 included in this campaign? And I was a bit surprised by that, but when you think about the nature of these campaigns, which is an outreach around common issues, the common issues applicable to Act 20 are really bona fide residence and sourcing, and other issues that might come up on an Act 20 situation are going to be less common and then less suitable for an outreach. Or it's possible that this is a sequential thing and the IRS is going to start with Act 20 and then they'll get to start with Act 22 and then they'll get to Act 20. Eli, thanks for joining us.
Pleasure.
That concludes this episode of Taking Shelter. We hope you found it informative. I'm your host, Peter Paulson. See you next time.